Now moving on to the next scope, that is scope of judiciary. So let us take an example of a great personality. When he died at the age of 100, Mr. V.R.Krishna Nariman, a great senior advocate, father of Justice Rohinton Nariman, had said, when Justice V.R.Krishna Iyer speaks, the whole nations listen to him. So who was he, sir? Justice V.R.Krishna Iyer was born in the state of Kerala, and his father was also an advocate. So after his enrollment, he joined his father's office and started practicing in state of Kerala. Thereafter, he was an activist. So he involved himself in a protest against the atrocities committed by the police officers. So he was imprisoned for 1 month. He was put in jail on false charges. Thereafter he was released. Then he joined politics and he became a minister in the state of Kerala, holding portfolios like home, even prison was under his control. So having visited the jail as a prisoner, he understood the prisoner's difficulties. So he, as a minister, had come out with legal aid to the prisoners, and there should not be any custodial violence against the prisoners. So he suggested reforms in prison as a minister. So thereafter, he became a judge of Kerala High Court and then a member of National Law Commission, and finally he became Honorable Supreme Court, as a judge of the Honorable Supreme Court. He was adorning the bench for 7 years in 1970s, and in his tenure he wrote more than 700 judgments, dear friends. So that means in a year he had written almost 100 judgments. All are reported judgments and expressing the founding fathers' ideas and their goals. And they were classic judgments, and I will touch few judgments to discuss about the contribution of Justice V.R.Krishna Iyer for the development of law. The most important case was Indira Gandhi versus Raj Narayan. What was this case, sir? The then Prime Minister Indira Gandhi was very powerful, and her election was challenged before the Allahabad High Court on the ground that there was some malpractice. She utilized the government officials for his election campaigning, and there was corrupt practice. Therefore, Mrs. Indira Gandhi's election should be set aside. So this was a challenge before the Allahabad High Court, and Allahabad High Court set aside the Prime Minister's post and set aside her election, and they also passed an order that Mrs. Indira Gandhi cannot be a member of Parliament for almost 6 years. So this was the verdict of Allahabad High Court. Against that verdict, now Mrs. Indira Gandhi was aggrieved, otherwise her post will be taken away. So she had approached the Honorable Supreme Court for seeking stay against the Allahabad High Court judgment. It was a vacation court. Generally the Honorable Supreme Court has a vacation in the month of May and June, and this matter had come up before Justice V.R.Krishna Iyer. He was a vacation judge, and Mr. Nani Palkiwala appeared for Mrs. Indira Gandhi, and Mr. Shanti Bhushan, father of Mr. Prashant Bhushan, he had appeared for Raj Narayan. Arguments were heard, and finally, as an impartial judge, he refused, Justice V.R.Krishna Iyer refused to grant stay against the Honorable Allahabad High Court judgment. But he showed a leniency by saying that though Mrs. Indira Gandhi ceases to be a member of parliament, but still she can hold the post of Prime Minister. Thereafter, after this judgment, the very next day, Mrs. Indira Gandhi declared emergency in our country. So as an impartial judge, as a courageous person, though the highest political post came and knocked the doors of Justice Iyer as a litigant, but still rendered justice without any fear or favor. And coming to yet another judgment, Maneka Gandhi versus Union of India. We all know that Article 21 of the Indian Constitution provides right to life and personal liberty. But where do we get right to water, right to clean environment, right to speedy trial, right against handcuff, right, all these rights, even right to privacy? In Justice Puttaswamy's case, that was read into Article 21. So how this got liberally interpreted, dear friends? It was because of the contribution of Justice V.R.Krishna Iyer in Maneka Gandhi case, wherein he had held that Article 21 should not be strictly construed, should be leniently construed, and bring all those valuable rights and read into Article 21. So he opened the gateway. That is why we have got innumerable rights under Article 21. And thereafter, he had always raised a question whether Honorable Supreme Court is for India or for Indians. If it is for Indians, all the Indians, even in down south, in Kanyakumari or from Kashmir to Kanyakumari, they should knock the doors of the Supreme Court and they should have access to justice. So therefore, under Article 32 is itself a fundamental right to approach the Honorable Supreme Court. But the doctrine of locus standi, that is, if you want to maintain a petition under Article 32 before Supreme Court, you must have locus. You must have competence to maintain that petition. But Honorable Justice V.R.Krishna Iyer, along with Justice Bhagwati, they introduced the concept called public interest litigation. They have diluted the doctrine of locus standi, and they said even the poorest of the poor can approach the apex court even by mere writing a letter and addressing to the Chief Justice or to any other judges. Those letters were considered as writ petitions and orders were pronounced by the judges. So PIL was the brainchild of Justice V.R.Krishna Iyer and Justice P.N.Bhagwati. So having said this, Justice V.R.Krishna Iyer, even after his retirement, he was a voice of millions and millions of people, and he had written nearly 100 books, dear friends. Can you imagine that? It is very difficult to have 10 publications in the journals, but he had released almost 100 books and 700 judgments within 7 years period. So they had achieved everything in this legal profession. So therefore we have seen two great personalities' life. From Judiciary, Justice V.R.Krishna Iyer. From litigation, we have seen Mr. Palkiwala. So what was their secret of success? Ultimately, I am coming to the conclusion, dear friends. What was the secret of success? According to me, their secret of success lies in 5 P's. First P stands for passion. Whatever they did with passion. Second P stands for preparation. When they prepared to render a judgment or when they argued the case, they had a very sound preparation. Third P stands for presentation, very efficient presentation. Fourth P stands for patience. That is most important. You do something but you don't expect the results. The result might be negative, so you lose confidence and ultimately you are frustrated. So they never lost their patience. Then finally, fifth one is perseverance, constant effort. Every day they try to see as an opportunity to equip themselves. So I repeat, passion, preparation, presentation, patience, perseverance, these 5 P's taken them to the next P, that is pinnacle in the legal profession. Therefore, dear friends, having understood these concepts, you must apply to you. Your mother can prepare food, but it's up to you to eat. Father can purchase book and hand over to you, it is up to you to read. So we have said the aspects of these great personalities, and I hope and believe that in other few decades there will be a lawyer standing here referring Ravisha, Jai Mishra, Vandana, Shreya Shukla as Mr. Palkiwala, as V.R.Krishna Iyer. I firmly believe that once record is set, there will be a record breaker also. I welcome you all, that you will be reaching the greater heights and you will prove yourself that you are an asset to this great country. Thank you so much, and God bless you all.